Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's presidential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Ever feel like you're using 5 different tools just to get one case out the door? If your tech stack is stressing you out, or worse, slowing you down, it's time for a different approach. The podcast recommends checking out e-Immigration's Immigration Software Buyer's Guide. It breaks down the signs that you've outgrown your current system, what to look for in a new one, and how to make the smoothest switch. Get the guide at get.eimmigration.com/resources to make smarter software moves in the new year, or click on the special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome, pod listeners and lovers, to another special episode interview. This one with a friend, Nicholas Perry, who I first met on an FBA Immigration Law Section panel a few years ago in Detroit, and who has been nerding out with me on case law ever since. A loyal pod listener, deep within the deep state of USCIS, now retired. Nick Perry recently ended his federal government employment after 28 years as an immigration attorney with multiple agencies throughout the immigration bureaucracy, most recently with USCIS. He will soon be opening a law office in Lincoln, Nebraska, concentrating on using his expertise to help other law firms with contract and consulting work, although he is open to other employment opportunities. I've included his LinkedIn profile in the show notes, but you can find him by searching for Nicholas Perry. Ever wonder what's going on within USCIS, especially with its attorneys? And at the service centers, ever wonder about them? This interview is for you. I hope you like it. Heads up, Nick's audio gets a bit better after just a little while. Let's jump into this interview conducted in late November 2025. And thanks for being a friend, Nick. Nick Perry, welcome to the Immigration Review Podcast.
Thank you, Kevin. Very happy to be here.
Correct me if I'm wrong. Long-time listener, first-time caller.
That is correct.
First-time interviewee. You and I met at the Detroit conference, the FBA conference, 3 or 4, 5 years ago. I don't know. I think it was actually during Trump 1. Maybe it was towards the end of Trump 1. It was a cool conference.
Yeah.
We were on a panel together. That was the first time I'd ever been on a panel with a government employee. I didn't know you guys were allowed to do it, which is one of the reasons I think that the FBA conference is so cool.
I did appear in my personal capacity, not in my government capacity.
Of course. Well, I'm glad that you're on the show. You're on the show now. You're allowed to speak now because you're no longer with the government. Isn't that correct?
That is correct.
Did you take the fork?
I did indeed.
Congratulations on your forking.
Thank you. We were given less than a full week to decide whether to take the options of departing because of how long I've been in the government and my age. I was able to take an early retirement and to also take a buyout and to work for not work for several months while getting my full pay, which was just too good of an opportunity for me to pass.
It sounds great. I remember at the time, it wasn't that long ago, it was earlier this year. By the way, we're talking on November 20th, 2025. There was discussion whether or not the whole thing was a lie, whether you could trust Elon Musk and President Trump to abide by what was an extraordinary promise to pay federal workers.
There were certainly concerns about that they did pay me. The retirement processing is still in the works.
Hmm.
It is the system both within USCIS and the Office of Personnel Management is so backlogged by so many people retiring. So I was supposed to get my pension already, but I have not gotten that yet. And some of your listeners may be thinking, ha, now you see what my clients have to go through deal with USCIS.
Uh, If there's a little Schadenfreude or whatever, Schadenfreude, whatever you want to call, we can do that. We can give it to an older, retired USCIS officer if that makes people feel good. They shouldn't though, because you're a very good person, Nick, and you've done a lot of important work for the U.S. government. There's a lot of individuals who've taken the fork, who've retired. I'm not going to talk to all of them on the podcast, although I know a lot of them, all of them have an interesting story to tell. You and I, however, have been friends now for many years. We see each other at the FBA immigration conference every year, and we chat, we email. You give me thoughts about the show because you seem to me from the outside to have kind of had a career at USCIS, or at least the last decade of kind of being the nerd, the case law guy, the guy who other people went to for immigration questions in USCIS. Is that right?
Well, that is partially right. I am, to be clear, not the only nerd and not
But-
the only person people go to, but particularly within the Service Center Law Division, I am one of the people who's most knowledgeable on the case law. And when I left Nebraska Service Center, one of my colleagues said, "How will we keep track of the Supreme Court cases without you?" And my reply was, "You should read the cases."
And that's exactly one of the reasons I want to talk to you. You worked at the Nebraska Service Center. You worked within, honestly, it's a black hole. I have no idea what's going on with USCIS. We meet officers at field offices, and then it's all paper. We send things to service centers. I don't know what they look like. I didn't know that there were people like you in them. I don't think a lot of this isn't public, and if it is, I don't think a lot of it is known. So let's start in reverse chronological order. What is the position you had just before leaving the U.S. government?
I was an associate counsel at the Nebraska Service Center within the Service Center Law Division, which is one of the divisions within USCIS OCC.
The Service Center Law Division, that's not limited just to the Nebraska Service Center. That would be all the service centers?
Correct.
And also, would you be providing services to the field offices or no?
Not unless you relate. There are plenty of cases that have ties to both a field office and a service center. And it may be the field office needs something tied to a service center issue. And then I would be involved with the local field office attorney.
What percentage of the USCIS Service Center people are lawyers as compared to non-lawyers?
A very small percent, well, let me rephrase that. There is a small percentage of people at the service centers in attorney roles. There are several attorneys that I
Right.
know who are adjudicators but are not in a attorney role, but it is, less than 1%.
So there is less than 1% of service center employees are in an attorney role. What is that role? What do these attorney brains do for the service centers?
Primarily two things: give legal advice and provide litigation support. So for legal advice, what would happen is we would have a box for adjudicators and supervisors to reach out to the counsel's office, or back when we were in a different building, we're able to walk in and say, "Hey, I have this question." And it could be something like, "Hey, this person has this conviction. Does that bar this benefit? Is this a legal marriage?" Lots of things. Is this a conviction or not because of diversion procedures in whatever jurisdiction? So lots of things primarily along those lines. Sometimes it's, does this meet the qualifications for an H-1B? is this a qualifying crime for U visa? Those are the sort of things. The other main thing is the litigation support. And that is when there's a lawsuit against a service or on a service center decision, I or my colleagues would be the attorney working with usually the assistant U.S. attorney, or sometimes oil on defending the case or reviewing the case and deciding if the decision was not proper, reopening and approving or reopening and issuing a new and proper RFE.
Well, or you could just grant it, Nick. Let's
And we
not have
could
the
grant
bias. It's
absolutely,
not
absolutely,
necessarily going to
absolutely,
an RFE or a Noid,
absolutely, and that frequently did happen.
Yeah,
And yes, we did grant.
I know, I'm just joking.
So
It's
you should, there we did certainly. There are cases that were wrongly decided and should have been approved. So yes, there are. So we get involved in those, and the first thing we do usually is review the denial being challenged, assuming it's a denial, and say, hey, is this right? And I've had ones like, why in the world did the adjudicator deny this? And others like, who thought this was a good idea to challenge this in litigation? Guys, this is a bad case. Why are you wasting some client's money by bringing this really meritless case?
It sounds like me and people like me have been working with you or against you for years, and we didn't even know it. When I'm writing my big briefs for USCIS that I think are all important and going through the categorical approach or explaining the law on fraud, I'm really writing to someone like you.
You are writing not yes, but not alone. It is collaborative process with the DOJ attorney when you are,
Well, that's
or are you referring when you were writing to the service center or writing the brief in the litigation?
I want to get to the brief and the litigation in a sec. I'm talking about submitting something to the service center. If I make it and not trying to do so, but if my brief is correctly well written, complicated enough, the issue is actually very complicated. Am I correct that, the line officer is probably going to bring in someone like you to be assisting?
That is what is supposed to happen. Sometimes my clients did not bother to check with counsel and move forward. But yes, when there is a complicated legal issue raised in the application or in briefs accompanying an RFE or NOID response, yes, then it would usually go to us and we would work with the adjudicators.
But it only gets to you if the line officer or the adjudicator identifies it. It's not the other way around with you guys triaging
Prior to litigation, that is correct.
prior to
We
litigation.
they only it's up to them to bring it to us. Busy as we were, we would much rather deal with an adjudicator bringing it to us at the adjudication stage than have to deal with it in litigation.
I very much am going to get to litigation in a sec, but I have a couple more questions. After all, it's not often we get to talk to USCIS folks. I always tell these adjudicators at the field offices in a very polite way, after I leave this room, it is a black hole. I can't contact you. God help if you're trying to call the 1-800 number. By the way, Nick, now that you're on the other side, you should just for fun try to call that 1-800 number. Try to get in, just see what it's like. Get into a tier 2 officer in a month, call you at 7 a.m. on a Saturday. Just if you're just a little curious, but
Yeah, I am
if you wanna know that pain.
I am well aware of what the black hole the
Hmm.
service centers are. For those who don't have a badge, they'll allow them to
Yeah.
enter the door.
How would people, is there any way around that? That's by design, but is there a secret email, a secret phone number, a way to get your case looked at and, decided by a human who's willing to work with you, or has it all been so shut off by design and you just got to work through the RFE or the NOID process and file a mandamus if it's taken too long?
you've correctly, is what is described on the web page is how you get in contact, which
Hmm.
I am very much aware does not practically work very well.
Yeah, I'm always curious. You're not in the government anymore, Nick. Don't give us state secrets, but it's interesting. I do understand why USCIS became much more formal. I know that there were, well before I became an attorney, there was fraud in the field offices, there were problematic adjudicators, and they wanted to centralize things, for example. So I understand why it has become so formal. I wonder if it's gotten a little too much so. I wonder if it's gone
Yeah.
pendulum swaying too much, but reasonable minds can differ. I'm curious though, this interaction between the field office and the service center. I file an adjustment of status application with a complex criminal matter. I'm filing that at a service center, but eventually it's going to a field office for the interview. And then once it goes to the field office for an interview, someone like you is no longer possibly involved. So, what is happening at the service center before it's getting sent to the field office for an interview?
Well, it's technically, you probably filed it with the National Benefits Center,
Okay,
which is, as a technical matter, not a service center, even
gotcha.
though it acts a lot like it. And it has, the Service Center Law Division does not support the National Benefits Center. But to the best of my knowledge, what happens is they make sure everything, all the documents are there, and do a basic check to make sure everything on paper looks good. It's very similar to what happens at the National Visa Center for immigrant visas.
Hmm. So then what is happening? What are the service centers that you assisted during your time? What are the service centers? And you mentioned VAWA.
So,
What kind of applications were you
oh, what
dealing
kind
with?
of
Yeah.
applications? Yes. So, so a lot of work on the U's, which are done both in Nebraska and Vermont. A lot of I-140s, a lot of DACA, some H-1Bs, but not too much. 601s and 601As. And at the end, TPS, we got that in Nebraska shortly before I left. So I was dealing with TPS. But those are the main form types I dealt with at the Nebraska Service Center.
Well, I-130s, would that go to the NVC or the end? Would that go to a
No,
service center?
they are adjudicated if they don't need to go to a field office at a service center. So I did deal with I-130s.
Let's get a bit nerdy if you don't mind, because we had talked about this famously to me, probably not to anyone else. We're on this panel in Detroit. They asked me how I think Patel is going to come out. Our firm was on the Patel case, which is quite the story. And I was a bit bullish. I'm like, there's no way. There's no way. The Solicitor General is not even defending the 11th Circuit's position. But then lo and behold, you were correctly saying, no, I think that they're going to uphold the 11th Circuit. And I said, who's this government dude just, towing the line, the government line? And you were absolutely correct. You were correct about many things, and that's no surprise. When decisions like Patel came out and recently Boarfa, giving exponential power to USCIS to get it wrong, potentially, and evade review. How did that play out inside the agency? It's quite the question, right? Yeah,
It is quite the question.
take a couple seconds.
Yeah, the what happens immediately locally of looking at the decision and thinking, okay, this would be useful in this litigation case and that litigation case. And then there's also usually, although I don't honestly remember whether there was or was not the case of Patel, guidance coming from OCC headquarters.
It's nerdy and in the weeds. Patel essentially, one interpretation of Patel is that, for example, you can't sue on an adjustment of status denial anymore in district court. Boarfa holds that you can't challenge an I-130 revocation, but of course you can almost surely challenge an I-130 denial still. People like you know that. Do you think that, I mean, is there guidance, for example, on I-130s that says if you think you've got a 204C issue, maybe lean towards revoking it rather than denying it?
Yeah, no, I do not. I've never seen such guidance, and adjudicators in all the guidance I've seen are not thinking strategically. The strategically implies a certain neutrality.
No.
That's in that sense, they are instead are, if it's not approvable, deny it. I've never seen anything that you should approve it and then revoke it. It obviously happens, but there's no guidance that, hey, take advantage of this court decision. At least no guidance I've ever seen. And I've looked at the guidance for I-130 for most of the form types I've worked on, the internal guidance, and certainly nothing devious like that have I ever seen.
That would be extreme, and by the way, USCIS would be insane to put that in writing. I mean, oh my goodness.
Yeah.
But and I think that would be
It,
extreme. I think Patel is a little less extreme, and it's been more everybody wants to be affirmed. You make a decision, you do want that to be the final decision. You think you're right. Do you think Patel and this understanding that actually maybe I can't be challenged at all in federal court on this, do you think that affected adjudicators or the people like you who knew the case law? Or is it just put your head down, do the work, no matter what the case law says about how it goes at the appeals or the challenge level?
I can't say it's never come into anyone's mind, but adjudicators are focused on here's the guidance I have. If it meets these requirements, approve it. If it doesn't meet these requirements, deny it or RFE or null it as appropriate. I don't think it gets into adjudicators' minds. So one place where related, but it predates Patel, when I've looked at draft decisions, I have said, if you think this should be denied as discretion, which is ultimately an adjudicator's call, not a lawyer's call, then you should add that with your, so that does avoid, gives a, particularly in the pre-Patel days, a stronger argument. But if I always couch my guidance in, if you think it should be denied on its discretion, you should add that to the decision, which sort of gets to it. But that comes from the lawyers, not the adjudicator.
On the litigation front, I've always suspected, on the litigation front, I know that someone like you from litigation is on the other side of the AUSA or oil. I mean, oil or the AUSA are just the attorneys. They have a client. That client becomes you representing USCIS, for example, in a given case. But how much of the drafting of these pleadings, especially when it's an AUSA in federal court, is being done by agency counsel itself, who, of course, are the subject matter experts?
It very much depends on, first, how experienced the AUSA is, and then how complicated the case, and then finally, just how much the AUSA really doesn't want to write this brief. So there have been briefs where I've done an immense amount of the substantive work. They've generally put in the language on their favorite bits on what's the standards for motion to dismiss or summary judgment. And then I would do the rest. Others were very much involved in that. And there are places, Eastern District of New York, Southern District of New York, Northern District of California, Western District of Washington, Central District of California, where the AUSAs are every bit as much of an immigration lawyer as you or I, because that's what they do. So they're very familiar with the law.
Your job was always to represent the agency, at least when you were working for USCIS. I've got the feeling sometimes, and being in the government a little bit, that sometimes the agency, be it USCIS and especially ICE, is steering litigation more, and sometimes it's oil or the U.S. Attorney's Office steering litigation more. Does the power dynamic change in your experience based on the presidential administration in these immigration lawsuits?
For the most part, no, but it is different for a very high profile case. But for the most part, what the line oil attorney or the line AUSA does is basically the same, independent of administration.
But at the end of the day, if an oil attorney says we need to settle this case, we think you guys are wrong, and you and your client, you and USCIS say no, we're right. How does that get resolved? What happens?
So then I raise it up to my headquarters, who raises it to oil, and then to the people in the civil division of DOJ that oversee oil. Often we end up losing anyway, but we USCIS in those battles. But yeah. So, and I will say one thing that is different potentially in presidential administrations is every appeal the government decides to appeal to a circuit court from a district court, has to be approved by the Solicitor General's office.
That's different now, or that it was always?
No, that what varies is how aggressive the political appointees in the Solicitor General's office.
I see.
So that doesn't change at the district court, but can change on what makes it to the circuit court and certainly, of course, the Supreme Court.
That is an exceptional amount of work for the Solicitor General's office. And you're not even talking the Supreme Court at that point. You're talking about just circuits.
Yes.
Immigration attorneys. Once you've secured a bond, let Gonzalez and Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez and Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez and Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
You were kind enough to provide me your resume before this interview, which no one has ever done before. I've never asked for it. I think I'm going to start asking for it. It's very helpful. I, of course, knew a lot about you, and it's not really changing what I was going to ask, but it does provide some other avenues to have discussion. For example, terrorism issues pop up all over your resume. You seem to have been involved in Trig for a long time.
Yes, and there's a story there.
You used to be a terrorist.
No, that is not. Although some people view my ICE pass as the equivalent, but that's a different situation, and that was many years ago too. So, I transferred from San Francisco. I know this is out of order, but I transferred from San Francisco to El Paso in 2001. Was an INS attorney. And the first week of September, my new boss said, "Hey, Nick, you want to be our national security attorney?"
The first week of September 2001.
Yes. And I thought, oh, that'll be cool. A couple interesting cases a week. And then, the nice conference every now and then, hopefully in a nice city. It seems like a great deal. And then the following Tuesday was September 11th, and this nice occasional little bit side gig became all of my job for quite a while.
Wow.
Yes, I've been involved in Trig issues since really 9/11.
So much of the people I talk to on this podcast have similar stories, obviously not factually, but that their career goes in a certain way in immigration based on events that they never anticipated and seemingly minor decisions that kind of turned into everything, just like that, or the decision to go into immigration alone. What about the trig issues interest you?
Part of it is I like understanding the complex statute, and there's few, if any, parts of the INA that are more complex than 212A3B.
It's wild. It's
You know,
insane.
and I've also been involved in perhaps one of the other more complex things on the visa numbers in 201, 202, and 203. But on the trig, I found it very interesting how these pieces link together. And also, you get involved with very interesting factual issues too, some of which, many of which I'm not allowed to tell you, and at times scary because people who work trig issues see the guys who, provided bedding or soup or set up tents, but there are also people who are actual terrorists who
Yeah.
actually are involved in really serious bad things, some of which, not all of which threatens the United States, but some of which does. So it certainly, trig very much gets into people who are not at all what Congress intended in 2001, but it also gets into people who are very much
I,
very bad guys.
I want to talk about that though. But before I do, I can't. These things you're not allowed to talk about. Would that pertain to your part on your resume when you're advising on legal issues and assisting in litigation related to Guantanamo Bay? Tell us about your time in Guantanamo Bay, Nick, and the
I do.
and the and the individuals, please.
So so in the beginning of I can tell you some.
Okay,
In the
please.
beginning of the Obama administration, there was a task force designed to work on closing Guantanamo Bay and finding places for the detainees to go. And DHS, which is where I was working at DHS headquarters, was one of the one of the agencies involved. I was not the main attorney at DHS, which went all the way to the number two attorney in the department. But there was a lot of litigation, and eventually, after several Supreme Court decisions, there was and still is litigation on habeas cases among those who were involved who are detained at Guantanamo. And I was the person at DHS assigned to review those briefs to determine if there were any U.S. immigration issues that were addressed and needed to be addressed. So I reviewed lots of briefs, both unclassified and classified.
That's a heavy job. If you miss an immigration issue with an alleged terrorist, I can't imagine that the agency would be pleased.
Yeah, no,
The overbreadth of the material support of terrorism, inadmissibility, and removability provisions is very much something that upsets me and is something that I like to litigate against. It does seem to me that if we really want to prevent terrorists from getting immigration benefits and removing them, it actually wouldn't be that hard. You don't need that complicated of a statute. But the way this is written, and all of these precedential BIA decisions, we're talking about cases on the margins and the precedential ones, and some of them that are actually disgusting. That's not matter of SK, which I see in your resume that you were the trial attorney on it, but that's the seminal material support of terrorism case.
yes,
You worked
yes.
on that case. I would like, and from matter of SK has, because of the dicta and the things left unresolved, have come a lot of the arguments that the trig community have been arguing for a long time. Is there a duress exception? Should there be? Is there a de minimis exception? Should there be? What does it mean to be material? I'm curious, Nick. I think it's clear where I come out on, but do you think both as a matter of policy and then as a matter of statutory interpretation, that there should be de minimis and duress exceptions to the material support of terrorism?
As a matter of policy, absolutely, with certain exceptions.
But as a matter of statutory interpretation.
So I do not think so, but there is the provision at 212A3D, no, not a 212D3B, for the exemption authority. And I think here is the problem. I think in there that authority has been underutilized. So you have, and you find on the USCIS webpage, the approved exemptions for, they don't call it de minimis, but the limit, I forget the exact wording, but and there is duress exemptions, but not exceptions. I think a lot of these problems could be solved with greater use of the exemption authority. But, and here's the problem, other than what you see on the USCIS webpage, it has not been delegated down from the secretary. So everything not on the USCIS exemption page is in the hands of the Secretary of Homeland Security, Secretary of State, and the Attorney General. And by that, I mean that person, not delegated. So you look at 245 or 208 refers to the Attorney General or the Secretary of Homeland Security, and it doesn't mean the Attorney General or the Secretary of Homeland Security. It means they're delegates. But with the exemption authority, it's never been delegated down, so that for anything that's not those exemptions that are on the USCIS webpage, you have to get an exemption from a member of the cabinet in consultation with two other cabinet members.
That's an absurd. That's a meaningless procedure. I mean, there is no procedure to request an exemption. It's this completely opaque internal mechanism. There's no form. These exemptions are made up by DHS. I mean, that's right. I mean, that's not in the statute.
They are not made up by DHS. It is a very lengthy tooth pulling process to get the ones we have.
That were made up. You might have pulled some teeth, but it was made up.
But they were not made up by DHS. You had to get National Security Division and oil at DOJ, get ICE and USCIS at DHS, and State Department all on the same page. So made up makes it sound easy. And as someone who spent many hours trying to get agreement on those things, made up makes it sound far easier than it actually was. This was a huge struggle to get the ones you see. I wasn't involved in all of them, but I was involved with most of them.
That doesn't sound easy, but also I just don't think that's how it should be. I mean, the attorneys should be able to argue what the statute means, not have to beg DHS to give an exemption that USCIS has made up, even if it was through a good faith tooth pulling process to get them. You listen to the show a lot, though. Azarumba v. Bondi, episode 280 out of the Fourth Circuit recently. The word material has to mean something, and it seems like all BIA precedent on this issue has completely ignored that. How doesn't material imply not de minimis, and doesn't it imply that doesn't get to duress, but doesn't, and that's what the Fourth Circuit said. I mean, Mr. Zarumba, he made a lot of meals for those Nigerian, warlord people. Doesn't material have to mean something?
So this has been something, that's been, without getting internal deliberations, been debated internally in the past, but the statute is not clear because it implies, yes, something, material as in substance, but it also means usefulness. And so it can, you could read the statute multiple ways. And, I will be extremely curious to see what happens with that Fourth Circuit decision, and in what in relation to the other case law. I'm sorry to disappoint you, my friend, but I think it could legitimately be interpreted the way you're saying, but it also could be interpreted to mean something not substantively material, but something supportive.
That doesn't disappoint me, and I've learned my lesson about going against you on case law or your predictions of what will happen. But I am curious, as someone who was somewhat involved, I suppose, in fleshing out the agency interpretation of this. If it is ambiguous, as you're saying it is, why do the interpretation that's going to bring up all of these people who are not the kind of people that Congress was thinking about when they passed this law? I mean, there's that one BIA decision from 2018, the name escapes me, where it's some woman in El Salvador or Guatemala where the guerrillas come and they threaten to kill her, or maybe they kill her husband and she cooks them breakfast at gunpoint, and they say you're barred from the material support of terrorism. That is why interpret it. What are the agency discussions internally? Because I know that's got to get brought up. Is it just fear that anything that's nice connected to the word terrorist is bureaucratic suicide?
So I say no because of your word just. Is it
Okay,
just
well,
that?
pick
Then
it
the
out.
answer is definitely not. So it is not just that.
Not just that. You're a better lawyer than me, right? I'm asking leading narrow questions. That concern, but you're implying that concern is present in these discussions, that we're going to err on the side.
In the interpretation discussions, absolutely. However, I would be shocked, and I do not have any idea. I would be shocked if that woman did not get a duress exemption, which is
By,
not.
but she shouldn't have to come to the agency to grovel. She should be do it by right, and it shouldn't be discretionary. That, of course, that is a disagreement. Maybe that is the answer to my question. If the agency has a way to keep as much power as possible, it's going to do so, especially when it comes to the word terrorism.
Yeah, and as you know, my solution is not feasible in that if just delegating the authority, you know, to grant exemptions to lower levels, because who wants to be soft on
Yeah,
terrorism? No one
right,
wants to be, but that assumes it's like, you know, Hamas and Shining Path
right.
and Hezbollah, not people supporting a guerrilla force opposing a brutal government. That we are fully on the side of those. So
Or giving a used car to a FARC operative with an
yeah,
AK-47 to your head.
yeah,
But that, and of course, an adjudicating officer shouldn't be put in that position, which is exactly why the case law, the BIA, really, I'm talking to the BIA and the Attorney General and the Department of Homeland Security leadership to give the framework that protects adjudicating officers. Like, hey, this is not what we think this means, and this cuts across all political party presidents. The BIA has gone, it seems to me, as cruel as possible on the material support case law, which then means that adjudicators put their career on the line by not also doing the same.
putting their career on the line implies it's an atypical situation. It is, it is expected, regardless of the case, regardless of the situation, to follow the law. And really, particularly in the current administration, would you want a situation where adjudicators don't have to follow the law?
No, of course not. You
Yeah.
you do that, and I guess I use flourishing language sometimes on the pod, and I admit that I've been a bit traumatized these last 10 months or so.
Yeah.
Kind of assuming that everyone thinks their career is on the line. Not necessarily the case. You do want adjudicators following the law, and that's why I get so passionate and upset with some of these BIA decisions, because those creating the law have a responsibility, because those who have to follow the law have to follow the law. Tell me about your time with the Office of Legal Affairs with the Visa Office with the Department of State.
So when I was at State until a few years ago, the Visa Office, as well as the Passport Office and Office of Overseas Citizen Services, were not part of the Legal Advisors Office. So they had separate lawyers. My boss was not the legal advisor, but was the Assistant Secretary of Consular Affairs. So it was a strange setup, but essentially I was a State Department lawyer. Rephrase. I was a State Department lawyer, even though I wasn't technically working for the legal advisors office. So yeah, I spent 4 years first overseeing the division, the team that does regulations and legislation, including the FAM, the Foreign Affairs Manual.
Mm-hmm.
So I was involved with that. I was not involved on the other team that deals with the consular officers and the advisory opinions and
Right.
legal net. But then I was promoted to be the deputy director in that office, which was the second number 2 person, and I was overseeing those.
Some of the FAM provisions that I need to follow, you've written some of them, or you've overseen attorney teams that did write some of them? Is that what you're saying, Nick?
Yes, I wrote some of them. I reviewed many of them. Yes, and also some of the regulations, the visa regulations too, in the CFR.
Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out.
Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America.
So, about my role with the visa office, which was very interesting, but it has been exaggerated.
Your role?
My role, the book I am holding, Border Wars, Inside Trump's Assault on Immigration by Julia Herschel Davis and Michael Shear. I make an appearance in this book.
Your name?
Yes. And it says, says, quote, Nick Perry, the lead immigration lawyer at the State Department,
Wow.
which is really impressive and
That
surprising, notably to several of my bosses who really thought they were
right.
more lead attorney than I was. Yes. Yeah.
Well, you can't be so upset at like, borderline fact fiction because I'm reading your resume here. And, so I've made Lord of the Rings references on the podcast before, and I'm a pretty big fan. I've read The Silmarillion, for example. I've read, of course, all the books and sat through the Netflix shows, which are just so upsetting to me, but they're not bad enough that I can walk away. I'm looking at your resume and I see publications, one of them amongst all your, immigration intellectual publications is Prince George of Ham, a novella published by the American Tolkien Society. Are you a member of the American Tolkien Society?
I am not anymore, but I used to be.
What does the American Tolkien Society do?
And so it produced, it used to have this periodical, the Minas Tirith Evening Star.
Oh my
I have no
God.
idea if it's still in publication.
Oh my God.
That would, which would have fan fiction as well as articles about about the Lord of the Rings and the other things of Tolkien. Of
So I kind of taking the story and I go making like side stories in relation
yeah,
to it.
right. So in the novella I wrote is a sequel to Farmer Giles of Ham, one of Tolkien's lesser and his best of his lesser works.
Yeah, I'm in way over my head here. I'm not gonna lie. I like to think that I'm a Tolkien and a Lord of the Rings fan, but I'm not even scratching the surface because there's another publication on here, and I mean this, Nick. I consider myself a nerd. I'm a legal nerd. This is legal nerd talking to legal nerd.
Yeah.
And I love you and respect you, and I think that we started jiving immediately because of that. But I am looking at this publication from July 2004, published with the University of Michigan, titled Middle Earth in Court: Legal Disputes Arising from Tolkien's Works. And I just
It is not a publication.
it's a conference. It was a presentation at a conference.
Yeah.
So let me please paint the picture. So I'm sorry, the University of Michigan has a Lord of the Rings Tolkien symposium.
No, it rotates from different campuses each year. So that year it was in Ann Arbor. So
What was the legal dispute that you focused on in your presentation?
I dealt with cases that mention Tolkien, and the one actual case that discusses the Lord of the Rings of a dispute on whether the Fellowship and the Two Towers were public domain or not.
That I'm not okay. So first of all, I'm actually quite interested by that. I am a bit disappointed. I was interpreting this as the presentation was you identifying potential legal disputes in Middle Earth and in the Lord of the Rings. Like if Gondor files suit against Mordor, they would never do that. Of course, they wouldn't have even the same legal framework, or I guess against Rivendell, against the Shire for water rights. That kind of stuff is what I was.
Yeah, I'm very sorry to disappoint you. I do mention when Bilbo returns on his journey, his items were being auctioned off, and it wasn't clear in The Hobbit, but it is clear in the drafts of the Fellowship of the Ring that the firm Burroughs and Grubb, mentioned in The Hobbit, is a law firm, not an auction house. So I did mention Burroughs and Grubb.
Amazing stuff. We might have to do a follow-up interview just about Tolkien. Turning back to less fun, but also interesting, maybe just as fun. It strikes me on your resume that during the Trump administration, you helped draft or you're involved with Executive Order 13780. What is that executive order?
I believe that's the travel ban.
What did you do with the travel ban? What
So is
was your
this going to
role?
end our friendship? I don't know.
Not at all. Not, hey, look, not at all.
So
Law's the law, and you
yeah.
need good people inside always.
So yeah, I was so, and I can actually, I can set the scene, assuming I'm remembering my executive order numbers correctly. But on the day Trump signed the original travel ban, I was at the visa office and we were thinking, what is this going to be? He signed it at 4:30 in the afternoon, but we didn't get a copy till 7:30 because no one thought send it to the visa office.
Because they're a mess.
And it was a week into the administration. We had seen a draft that's published in the Washington Post, and we started issuing guidance, unlike my friends at DHS who wanted to wait. And so I spent many hours, not too many hours, because it started at 7:30, working on guidance for that. And then I spent the whole weekend working on guidance, and then the following weekend dealing with litigation.
Yeah.
So
No, that's the unthought part of all of this. I got back into immigration. To be clear, you've listed in your resume this is a June 19th, 2017 memorandum, but the executive order might revert back. Of course, you didn't draft
yeah,
the executive order.
yeah,
I got back into immigration. My federal clerkship was ending around the time of the travel bans, and that was what moved me back in. I was
yeah.
horrified and disgusted by the travel bans. I still am, but that doesn't mean that you as a federal government employee have a right to do anything but to,
Yeah.
do the
And
best of what's being instructed of you so long as it's legal.
yeah, and that was the goal. Not the goal? Let me rephrase. That is the role of a government employee is like what apply the law, what is legal. And I believe then and believe now, independent of policy objections, that the travel ban was lawful, particularly by the third version, which was the one that reached the Supreme Court. And I know people who were involved in figuring out the countries to be applied. It is assumed it's all based on discrimination, but I know there were real concerns for those countries. The fact that A, it's legal, and B, there are real concerns for it doesn't mean the hammer that was applied is appropriate. But I think there were the countries that were listed in the third version, not the first version, were countries that we really do have significant issues with information sharing, and that we don't know who the applicants are as opposed to the vast majority of countries.
I think one of the problems is, and I have very little evidence to support it, but I think one of the problems is like with the travel ban, for example, is you might think that, and you might be right, and you and all the other brains go to work putting in a legitimate policy objective. But when it's drafted and when Mr. Trump and Mr. Miller put these things out, they're thinking Muslim ban, they're thinking maximum pain, and they're thinking politics. And so those inside, those working in government trying to do their job are inherently sucked into the politics of it because it's being done initially for politics. And then, over a period of months, and you say 3 iterations, it becomes something a bit less. But those initial political feelings, which to me were the initial intent or a primary intent, they don't go away, even as it gets whittled down and changed to sustain appellate review. What do you think about that statement?
I think you are right as far as the objectives, but the document that came out in the end
Right.
was based on real concerns. I think the problem isn't that those countries were named. I think it's more such a brutal instrument was used to deal with meaning the travel ban, to deal with the issues raised by those countries not sharing concerns. And I did review the third iteration of the travel ban. It was a Saturday or Sunday evening, and I got a draft on my work phone while having dinner with my son. And I had
Absurd.
45 minutes to review this document on my phone. I just gave my son my personal phone to play games with all you wanted while I was there at dinner looking at to make sure that, I was, and to be clear, I was one of the least involved people, but it did get to me and I did review it. And at the end of the dinner, we were the last two people in the restaurant. Luckily, I was able to get out before they kicked us out.
I love hearing stories like that though, because and I've been involved not like that, but in important things and in the moment. Sometimes it's so ad hoc. Yeah, the momentously important, even if you disagree, role of reviewing for legality the travel ban and making suggested edits and the like, something you know is going to Supreme Court is happening, with just you, relatively low level you, on a phone in a restaurant, and that's how government works. And that story happens in Washington every day, every week for
Yes.
sure. And
Yeah.
it's kind of scary, it's kind of cool at the same time. It's definitely interesting.
Yeah.
I have to pick up my son from daycare. I've loved talking to you, but
Yeah.
before we go, you are an individual who's had a lot of immigration life, and we have barely scratched the surface. I know you've got stories. You've told me some. Is there a story that comes to mind, just an interesting immigration anecdote that you could share before we go to leave this episode with?
I think the interesting one is how I got into immigration.
Please tell. I
It's
don't think
all
I've heard
due.
it.
No, you have not. It's all due to President Benjamin Harrison.
Wow, you're not that old.
No, I am not that old. Our 23rd president, elected in 1888. And it's not because of the Immigration Act of 1891 that he signed. No, after the engineering fell through, I was a history major and got a summer job at the home of President Harrison in Indianapolis. That tour guiding experience helped me get my next job, which was as a tour guide at the Indiana State House. That was a political job. I got to know some of the members of the House of Representatives in Indiana, one of whom recommended me for a job working for a member of Congress in Fort Wayne, Indiana, as a caseworker in her office in Fort Wayne. And there, my primary role was dealing with immigration cases when people reached out to their congresswoman to say, hey, can you help me with this case? Can you help me with a letter to the consulate? Why is my case taking so long? And this was in 1990 and 91 and 92. Things weren't taking that long in relation to 2025. So I got that immigration experience. At that point, I thought, hey, I could work in a museum. I could work for a politician. I found myself working in bookstores. Nothing wrong with working in bookstores.
Not at
That's not
all.
where I wanted to go. And I said, guess I'll go to law school. So went to law school, and I eventually hired by a judge in Eeyore, in the administrative law judge in the office of the chief administrative hearing officer that does employer sanctions and discrimination.
Okaho.
Okaho, yes, Okaho, and working in the tower in Falls Church where the BIA is. And I asked my boss, like, why'd you hire me? She said, it's because unlike most of the other applicants, I had immigration experience, meaning referring to my time working for the member of Congress. So had I not worked for the home of President Benjamin Harrison, I wouldn't have worked for the state legislature. I wouldn't have gotten the congressional job. I wouldn't be gotten that first job in immigration, and I wouldn't be talking to you right now, and the listeners wouldn't be listening to this and would be listening to something else.
Thank you for that story. And it's like so many, really everybody's story. I don't know. I'm sure there are people who have known they've wanted to go into immigration from the very beginning, but they don't seem to be on my podcast. Maybe one day they will. I love the
randomness of everyone's career path in that regard. Final question, though, as the clear historian you are, the reader, the somewhat encyclopedia on immigration, what is President Harrison's views on immigration? What's his most prominent immigration policy? What's his involvement at all in the late
So
19th
he
century?
signed two immigration acts, the Geary Act, which was an unfortunate extension of the unfortunate Chinese Exclusion Act.
Mm-hmm.
And the other is the Immigration Act of 1891, which was significant for, among other things, it created something called barring people from being convicted of a crime involving moral turpitude.
Unbelievable.
So he signed that, as well as barring polygamists. Also related to me, that law was one of the first steps in creating an immigration bureaucracy, because that law created the superintendent of immigration in the Treasury Department, and the baby step of eventually the massive bureaucracy that I spent 28 years in.
I had absolutely no idea what the answer to my question was, and I had no idea whether you knew, and you just knocked that out of the park. And by the way, there's been a lot of value in this conversation, informing listeners of where the CIMT concept originates with President Harrison. I think that's actually the most value, and it really just explains everything, why we were stuck in a late 19th century idea of inadmissibility. So thank you.
Yeah, well, although public charge was before him.
Okay, public charge. But before that was just being Chinese. So,
Just being Chinese.
That's
Otherwise, it's up to the states on who they allowed in or not.
Nick, it's always a pleasure to speak with you.
Sure,
I hope that you end up at the FBA Immigration Conference this year. I hope I do too. I know we'll see each other again soon. Thanks so much for coming on.
Sure. Thank you, Kevin.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.